Right now on the Daily Debrief, sentencing for actress Felicity Huffman in a college cheating scandal. Also, R&B singer R. Kelly is again in legal trouble. His attorney says it is not his fault. And
I'm really, really sorry, and I understand.
the woman acquitted of murdering her baby after her high school prom speaks at sentencing on a lesser charge. Plus,
strangled her until he had choked the life out of this little girl.
prosecutors say she was stuffed in a suitcase and found dead in Florida waters. They want this man put to death. The Daily Debrief recaps the day in court. It's Friday, September 13th.
Welcome to the Debrief, everybody. R&B singer R. Kelly is wanted again in state court, but federal authorities just won't let him go. R. Kelly facing 2 counts of engaging in prostitution with a minor after a Minneapolis, Minnesota concert. A Minnesota judge issued a bench warrant to R. Kelly for failing to appear, but R. Kelly's attorney says there's a good reason for that. Kelly is being held in a federal correctional facility in Chicago on sex crimes charges. Minnesota prosecutors say no attorney approached their office or filed an appearance, but R. Kelly's attorney, Steve Greenberg, took to Twitter to dispute that claim. He said it is irresponsible for the media to report R. Kelly failed to appear in Minnesota court today. I was not served with any notice of court proceedings. Neither was he, nor was he. I did not resist his appearance, nor did he. He is in custody. It is the prosecutor who must obtain a court order for R. Kelly to appear, and it is the prosecutor who must go get him, as here he is in custody elsewhere. They do not just give him a travel pass from federal custody. And now to sentencing today for the actress who pleaded guilty in a college admissions cheating scandal. Felicity Huffman told the judge she felt desperation to be a good mother when she paid $15,000 to have someone fake her daughter's SAT scores. Prosecutors asked for 1 month behind bars, but a pre-sentence report recommended less. The judge finally issued a sentence of 14 days behind bars, a $30,000 fine, 250 hours of community service, and 1 year of probation for Huffman. A Connecticut judge has issued a gag order in the case of a missing mother of 5, but there are legal questions tonight as to what the order might actually accomplish.
Jennifer Dulos disappeared nearly 4 months ago. Her estranged husband, Fotis Dulos, and his girlfriend, Michel, are facing charges of hindering prosecution and tampering with evidence. Yesterday, at a second arraignment, Dulos' attorney, Norm Pattis, sparred with a judge.
Our view is when the state's got some proof and more than abstract beliefs, it will know where to find us. This business of seriatim arrests on de minimis
Well, counsel, this is not the time for the closing argument.
Oh, it is a time for it, Judge. It is a time.
If you wish to make a closing argument, counsel, if you wish to make a closing argument, you can wait until after, if there is a trial, the trial.
If the state waited before publishing its warrants and having the Deputy Commissioner, Department of Public Safety, talk about the tests that were out there, we would wait. But since the state can't, we won't. We're eager for this fight, and when the state's ready, bring it.
The judge was not happy, but it appears Pattis was trying to put on the public record what he wanted to say to the press gathered outside.
We've got 3 words for the state. Bring it on.
The new gag order generally reminds the defense, the prosecution, and the police of their professional responsibility duties to ensure Dulos' right to a fair trial. In issuing the order, the judge noted leaks by the police and statements by Dulos' attorney, suggesting Jennifer Dulos may have ran away or plotted a bizarre revenge suicide. While the judge's order seeks to curb such statements, it allows attorneys and witnesses to discuss information contained on the public record, which, ironically, is written by attorneys and witnesses.
With me tonight are attorneys Katherine Smith and Michael Bryant. They're on the record here on the Debrief. Katherine, I complain about this issue constantly. I've been doing so for years. This circular logic in the professional conduct rules, which are now codified in this gag order. Well, you shouldn't be talking, but you can talk about what's on the public record. And by the way, witness affidavits and attorneys' pleadings are on the public record. Statements made in an arraignment are on the public record, and that's just what we saw.
Exactly. That's exactly what we saw. It pushes the attorneys to wind up making all these hyperbolic statements and closing arguments in any public forum that they can just so that it can get to the press. It really doesn't curb the speech the way they want it to.
Michael Bryant, attorney Norm Pattis, the defense attorney we just saw, says this really changes nothing. I anticipate more of what I pointed out in the hearing that I attended yesterday. Statements said in court, they get repeated outside as well, but it's not a good look to be talking over a judge.
No, of course not. And what they should have done to make it more effective was to close the courtroom to proceedings, seal any records filed, and do the gag order. You got to do all of it or you're not going to get much of anything done. And it's way too late anyway. This thing's been going on too long. Too much is out there in the public record.
And on it goes. Well, sentencing today for the Ohio teen accused of murdering her newborn baby 2 days after her high school prom. A jury acquitted Brooke Skylar Richardson of murder, manslaughter, and child endangerment, but convicted her of abusing a corpse, the least serious charge she faced. The state's circumstantial case ended like this.
With regard to count 1, we, the jury in the above captioned case, find the defendant, Brooke Skylar Richardson, not guilty of the offense of aggravated murder. Verdict form 2, involuntary manslaughter. We, the jury in the above captioned case, do hereby find the defendant, Brooke Skylar Richardson, not guilty of the offense of involuntary manslaughter. Count 3, child endangerment. We, the jury, find the defendant, Brooke Skylar Richardson, not guilty of child endangerment. It does say we further find the defendant did not cause serious physical harm to the alleged victim. Verdict form number 4, we, the jury in the above captioned case, find the defendant, Brooke Skylar Richardson, guilty of the offense of abuse of a corpse.
The infant's young father testified at trial. The father's mother spoke out with disgust today.
5 months and 28 days. That's how long after the DNA test we sat wondering. But Skylar knew and didn't tell Trey. She's known from the very beginning it was his. I've not only watched my son become a totally different person, and I will leave his medical diagnosis private because she's done enough to him. But I can personally tell you I've continuously been seen for depression, panic attacks, anxiety, and sleep issues. I would have taken her in with Trey and raised her with no questions asked. But now instead, every May 7th, I don't get to have a birthday party for my first grandchild. Instead, I get to send her balloons to heaven with notes telling her how much her daddy loves her, how much I love her, how much we all love her, and how much we all wanted her.
Skylar Richardson's father made these brief remarks.
Your Honor, this has been a difficult ordeal for the entire family, including the defendant's side or the prosecution's side. My daughter is suffering from an eating disorder and we're concerned for her health. Anything you can do to help us get her home soon so we can take care of her, we greatly appreciate it.
And the defendant herself apologized for what happened.
Thank you, Your Honor. I would do anything and above that you ask, and I understand. And I just wanted to say how sorry I was. I can sometimes be selfish, but I would like to think that I've become better in the knowledge that I've upset everyone and hurt so many people with what I've done. And I'm forever sorry, and I'm so sorry. I'm really, really sorry, and I understand. And thank you.
The judge kicked off this sentencing proceeding with a message to the community about why he believed having cameras in court was so important.
I think there is some value in the community having the opportunity to actually watch this trial. I only have 40-some seats in the courtroom. So it's out there. So if people want to know what happened in the trial, they can go watch for themselves. They don't have to rely on what somebody posts about it or what somebody tweets about it. They can see the actual evidence that was presented. One of the reasons that I did this is so that the community, whether they agreed with the verdict or not, would have confidence in the way that decision was reached. So if somebody comes up to you and talks about how we have a baby killer that got off in Warren County, or we have an innocent person who was convicted and didn't do anything wrong, we can direct them to the actual evidence so that maybe you can get a better idea of whether or not they have an accurate opinion of whether justice was served in this case.
Exactly, and our entire archive of this trial is online. That is how the judge started this proceeding today. During the sentencing, though, he went all political.
I've always sort of thought of this case, Ms. Richardson, as a story of two little girls. Skylar Richardson and Annabelle Richardson. And, you know, I have a daughter about your age, Ms. Richardson, and I have a granddaughter about the age that Annabelle would be right now. The jury found that the state did not prove that you were guilty of killing your baby, either intentionally by way of aggravated murder or recklessly by the involuntary manslaughter. But in all of this mess that we have with this case, I think what often gets overlooked, Ms. Richardson, is just how precious life is. Your life, Annabelle's life, life is precious, and it should be protected, and it should be guarded in all respects. And I have reviewed all of the expert reports in this case. I listened to the expert's testimony. I firmly believe, Ms. Richardson, in fact, I know in my heart that if you would have made different decisions in this case, Annabelle would be here today. And I know that might be difficult for you to hear. Some people are inclined to think to themselves, you know, this is America. We kill unborn babies every day. But I don't look at it that way, Ms. Richardson. And the law does not allow me to consider the acts that you took prior to giving birth. But I think that your choices before birth, during birth, and after show a grotesque disregard for life. And I think when I look at this case, that to me is what offends the community sensibilities. But because of policy decisions that are beyond my purview, the jury was not permitted to consider those things, and neither am I. So I don't hold those things against you in the sentencing.
The judge's sentence was credit for time served, 7 days, and then 3 years of basically probation. If the defendant violates that, she could go to jail for a year. Katherine Smith, Michael Bryant, what do you think of the judge's speech? Michael, I'll start with you.
You know, maybe a bit much for what he was trying to do, but I really think it was interesting how he contradicted himself. He mentioned that the community sensibilities would be offended by what she did before, during, and after, but those things can't be part of the jury's decision. Well, he's basically saying the statute is not proper in this case. I can't even consider those things. So I think maybe he's helped for purposes of appeal.
Katherine, what do you make of that judge's speech? Did it come across like he was complaining about the law as it's written, or was he personally saying, I think you should have been found guilty of more counts?
I thought he was trying to make a speech. I think he was using this forum to make some sort of statement, whether that's about him personally or how he was presiding over these proceedings. But I was really struck by how he related her to his own family. He went very personal, made a point of saying that what she did was wrong, but that he had no power to do anything about it.
Did it mess up the presumption that the judge should be unbiased?
Yes.
You think it did. Michael, what do you think?
Oh, yeah, there's no doubt about it. Yeah, he had some ulterior motive.
In the speech from the defendant herself, Katherine, what did you make of that?
I just don't think it's sincere. I don't think it's sincere at all. I think it come across again as this almost like babyish way of talking about the circumstances that are very serious for a young adult.
Michael?
I disagree. Yes, we look at this differently. I think it's a reflection of her upbringing, how her parents treated her like a little baby. She hasn't matured. She is emotionally immature, and that's what you hear and see.
Many opinions on this case, and we will not settle them all here, so on we move. We are following 3 additional criminal cases still ahead here on The Debrief. The case of the Georgia beauty queen found dead in an orchard, plus opening statements in the case of a 9-year-old girl authorities say was stuffed in a suitcase and ultimately dumped in Florida waters. That case and more when we return. Another hearing today for the accused killer of Georgia beauty queen and teacher Tara Grinstead. Attorneys for defendant Bo Dukes are asking a judge to allow them to tap into government money to hire defense experts. Normally that is allowed for indigent defendants, but only when they're represented by the actual public defender. In this case, Dukes is represented by private attorneys who are working for free. Day 3 of testimony today in the South Carolina trial of Sidney Moorer. He's the man charged in connection with the disappearance of a woman named Heather Elvis. Moorer was dating Elvis, and Elvis has been missing since December 2013, almost 6 years ago. Sidney Moorer's wife, Tammy, was convicted in a separate trial last fall of kidnapping Heather Elvis. The defense went after an investigator in the case and said the investigator could not find any evidence linking Sidney Moorer to Heather Elvis on the night in question. But on redirect, prosecutors said the investigator did determine Moorer suspiciously took down a surveillance camera in front of his home. Here is cross-examination and then redirect.
You found no physical evidence linking Mr. Moore in Miss Elvis's car.
No, sir, not that I'm aware of.
And in Sidney's F-150, there was no evidence linking him to Miss Elvis having been in that car.
There may have been, but by the time I was able to do anything with it, obviously from the video, there was no point in trying to obtain any DNA or anything from that vehicle. It had been cleaned out.
So as a no, we ultimately did not.
No, sir. Yes, no. I could clearly see that day on the 20th that there was a camera lens there. Now, when I looked at the video from the system, the newer system that had been installed in the house, is when I see Mr. Moore go up that staircase with the new cameras powered on, you know, and you kind of get a feed of somebody walking through. It's like you're getting seasick. You're walking through the room and he's carrying a video camera that's showing live, and I'm looking at this thing, and all of a sudden I see the green wall, and I stop the recording and I look and I start going frame by frame, and that's when I see the pictures that you see there in those two exhibits of a mounting bracket and the hole in the ceiling, and that is the exact location that I had seen the camera in.
And that case grinds along next week. And finally tonight, to the opening statements of the death penalty trial of a Florida man accused of killing a 9-year-old girl. Felicia Williams disappeared in 2014 and later turned up near a causeway in Old Tampa Bay. Defendant Granville Ritchie, who goes by Trevor, is accused of sexually assaulting the girl, beating her, and strangling her to death. At some point, prosecutors say he put the girl's body in a suitcase. Here is the state's opening statement.
This defendant, Granville Ritchie, who took this little girl from her home in Tampa, took her to Temple Terrace, and took her into this apartment, which became, for this little girl, a place of nightmare. As soon as he was able to get rid of the obstacle, Ebony Wiley, who was an obstacle between him and that little girl, the evidence will show that he put his hands around her throat. He strangled her. He strangled her until he had choked the life out of this little girl. Why would a grown man, 35 years old, attack a little 9-year-old? The evidence in this case will be crystal clear as to his motive. The evidence will show during this attack that he attacked another part of her body, a very intimate part of her body. He acted fast and quick. He raped and murdered this little girl. Felicia Williams' life meant less to this man than his sexual desires to violate her. And that is the value this defendant placed on human life and on her life.
The defense reserved the right to give an opening later during this trial. The state's first witness was the victim's mother, who described how her daughter, whom she called Sugar Plum, went missing.
I questioned her, and I asked her, I said, well, what do you mean about Felicia's missing? And she was like, I don't know, she's missing. I said, where were you all? And she told me that they were in Temple Terrace. And I said, well, where you're at now? And she said they was on a lake in front of the liquor store, which is in Belmont Heights.
And so when you asked Ebony where she was at that moment, she had told you she was in Belmont Heights?
Yes.
And was Charlicia with her at that point?
Yes.
Okay. Did Ebony tell you anything else in that phone conversation that you recall?
No, all I said was, you mean to tell me you in Belmont Heights and you left my baby way back in Temple Terrace? And she didn't say anything. So I told her, I said, well, you need to beat me over there. And I said, you know, I have to involve the law enforcement. So and she said she knew.
Ebony Wiley is the co-defendant accused of giving the victim to the defendant. She lived next door and is charged with giving false information to police.
Ebony Wiley and Granville, I believe.
Okay. You said the name Granville. Had you, prior to May 16th, 2014, had you ever met anybody by the name of Granville Ritchie?
No, ma'am.
Had you ever met anybody by the name of Trevor?
Yes.
That day that Ebony Wiley and the individual in the silver Lexus came to pick up your sister, did you want to go that day?
Yes, I did.
Did you ask to go with Ebony that day?
Yes, I did.
Were you allowed to go with Ebony that day?
No.
After that day when Felicia left with Ebony Wiley, did you see your sister again?
No.
Let's go back to our guests one final time tonight, Michael, Bryant, Katherine Smith. So, Katherine, it sounds like we have these witnesses who are relatives of the victim putting the defendant and the victim together, and that's key for the prosecution.
Absolutely. I mean, we know that Ebony, who was sort of like a godmother to the victim, really, whether intentionally or inadvertently, helped to orchestrate the victim's presence within the defendant's apartment. It's horrible.
Michael, Bryant, let's talk about the tactics here. The prosecution had some strong language in that opening. I thought it was blunt. I thought it set a good tone for the state's case.
I think it did. It might have been a little bit much, a little too detailed, but I mean, it is a complex case, and ultimately the jury is going to need to follow that story, and if he can help them do that, that's his job.
Exactly. Okay, now the defense chose not to give an opening, and sometimes that happens. Katherine, why might that be?
Well, a lot of times the defense really doesn't know where they want to go, because in part of they need to be reactive to what the prosecutor's evidence is. And so until today, they really didn't know what the prosecutor had to attack them with. So a lot of times the defense will sit back, see what happens, and then hit it hard in the closing.
I wonder about that, Michael. You know, sometimes is there a discovery nightmare that's going on here? Because in most states, both sides really get to look at what the other side has. And I thought Florida was rather open with that. Is there something potentially going on here behind the scenes?
Are you suggesting a Brady violation or something?
I wouldn't want to do that. I'm not suggesting. I just wonder. It just makes me wonder sometimes. And Katherine just jogged my memory yet again here.
Well, I hate to agree with Katie, but I will. That's just sometimes a strategy, that they want to leave the jury with a new opening before they begin the defense case.
And that could be what's happening here. Sometimes it's helpful, though, to at least bring up the burden of proof information off the bat. But there's a strategy here, and we will watch and see as the case moves along. Appreciate the time tonight. Katherine Smith, Michael Bryant, good to have you here as always.
Thanks, Aaron.
Thank you.
And that's all the time we have on The Debrief. Our live coverage of trials across the country resumes Monday at 9 a.m. The Debrief back here Monday at 5 Eastern. We'll see you then.